The Supreme Court will tomorrow consider Centre's affidavit in which it has informed the court that the National Disaster Management Authority has recommended a compensation of Rs 50,000 to the family of each person who died due to COVID-19. The eligibility for relief will remain subject to the cause of death being classified as COVID. Certification and grievance redressal will take place as per the rules specified by the Union Health Ministry and the ICMR. The ex-gratia relief will be given by states from the coffers of the state's disaster relief fund. The District Disaster Management Authority will have to disburse compensation to the next of kin of deceased, and all claims will have to be settled within 30 days of giving documents via Aadhaar-enabled direct benefit transfer. The certification committee will have to clarify the reason behind rejection of claims, and the Centre has made it clear that the ex-gratia relief will continue for deaths in future waves of the pandemic. It remains to be seen to what extent the affidavit will be accepted by the top court and whether the Union government will also be asked to finance some portion of the ex-gratia relief which is proposed to be paid to families of the deceased. In June, the top court had asked the Union government to frame guidelines for paying ex-gratia compensation to families of all deceased COVID patients. Around 4 lakh Indians had died by then due to the deadly disease since its outbreak, and the deaths are still continuing. Noting that the National Disaster Management Authority failed in discharging its statutory duty to give financial relief to families of deceased COVID patients, the Apex Court had asked the NDMA to put in place guidelines within 6 weeks to compensate the kin of deceased COVID patients. The time has been extended after the Union government has repeatedly sought extension from the top court. The Prime Minister-led NDMA is free to decide the quantum of compensation to be paid, as the top court back then had refused to enter the executive domain of fixing an amount of money. The court had held that while the Union government is bound to provide a minimum standard of relief, including ex-gratia compensation, it also has to decide its own priorities, be it looking at providing food, shelter and transportation to migrant workers or dealing with the effect of the pandemic on the economy. Centre had been asked to consider the National Insurance Scheme for disaster-related deaths proposed by the 15th Finance Committee. The committee had also proposed a feasibility study of the following insurance interventions by the NDMA, which included synchronizing relief assistance with crop insurance, risk pool for infrastructure protection and recovery, and access to international reinsurance for outlier hazard events. Rejecting Centre's stand, which had denied financial relief to kin of dead COVID patients in view of increased expenditure during the pandemic, the court had pointed to the Union government's obligation mentioned in the National Disaster Management Act.